Good morning, everybody. Thank you all for coming out this morning. We're going to go ahead and get started. I know a few more people had RSVP'd, but they will show up. So we'll go ahead and get started. We have a great presentation this morning. Some folks from the EEOC, the Equal Employment Opportunities Commission, have come out to join us this morning. So thank you all so much. So we'll go ahead and start. I'm probably going to mess it up. Let me see. With Marjan Hedayati. And then also Monica Kalunga will also be our other presenter this morning. So thank you all for coming this morning.
Hello, good morning. I'm so happy to be here. Let me introduce myself. My name is Marjan Hedayati. We'll have another presenter after me, my supervisor, and as well as called our outreach coordinator, and that's Monica. We'll go ahead and get started. Oh good, the slides are up. We're going to talk about self-advocacy and how you can advocate for yourself, and what EEOC is about, how you reach to us. I'm going to tell you a little bit about my background, where I'm from, so you know who I am. I was born in Texas, lived in California, grew up, graduated there, went to CSUN, then Gallaudet, graduated there. I was in the class of 2014. Studied communication studies. So after that, I worked sort of odd jobs, Kendall as a substitute teacher. And then I saw in USA Jobs. That's a place where you can find jobs for federal agencies. And there was an investigative support assistant job. So I went ahead and applied to that position, and I loved it. My job was responsible for sort of engaging with people to find out what kind of discrimination they had experienced. And then later, actually just last year, I got promoted as a federal investigator. And so it's been my first year as a federal investigator. So I've had 4 years of federal service. So let's talk about what is EEOC. What do you think EEOC is? It's where you can apply for or submit a claim as a federal discrimination, saying that employers can't discriminate against you, and so you can apply. You can file a claim because you don't want to make that worse. That information is right. That's exactly what we're here for, to make sure that you don't experience any kind of discrimination. Make sure a company doesn't violate federal law. Any other inputs on what EEOC is? So the U.S. Equal Employment Opportunity Commission, we enforce the laws that we have and make sure that companies, if they commit discrimination, that we make sure that we address those issues, that they are not violating federal law. So as an applicant, like if you were to apply for a job and then they turn you down for some reason, then it could be discriminatory for any reason, right? And so I'm sure for anyone who's experienced discrimination in the workplace knows what I'm talking about there. So what types of discrimination might there be? What kind of discrimination is there? Disability? What else? Better. If someone, like you said, they want to sign So when we can see you, but like the interpreter were to copy you, or maybe you come up here, then that might be better. But we need to be able to see her sign during this particular, the back and forth. I can go ahead and copy. Okay, great. So I'll copy what you sign, so what you sign I'll copy, okay? So when I asked what kind of discrimination, she mentioned disability, and then I asked what else? Any other? Any other guesses? Diversity? Gender? Age? Race, right? Any else? Any others? Religion? You got some of those right. That's very good. So disability, age. So disability is broader than just deafness, right? Many people think that involves just being deaf, but it doesn't. It could also be blind, person in a wheelchair, an amputee, bipolar, schizophrenia. Age, and you think it might be everyone, right? No matter what age, but it's actually not. It's 40 or above. If you're under than 40, then it's not. It doesn't apply to you. Race can be white, black, skin color, Indian, Middle Eastern. Color is based on your skin tone. National origin is where you're from, Europe, Middle East, Japan, Asia, India. Genetic information, so that could be based on your family history, medical history. Particular workplace and interview various people there, maybe HR, maybe witnesses, the person who you made the discrimination complaint against, and see if there was actually discrimination and see if there was actually a violation. And we'll see what we can do to sort of negotiate for resolution, like a settlement, which could be financial. Not everyone gets money. Could be money, could be training, could be changing policies, those kind of things. My job is to ideally, if there is discrimination, to be able to change that company's, whatever's happening in that company to cause that discrimination, to change that in that workplace. So are all employers covered by the law? The question is, are all employers covered by the law? Somebody said no. That's right. Any other ideas? I'll explain why the answer is in fact no. On the next slide, I'll explain why. I think if there might be some specific rules for specific companies or specific criteria that you actually have to meet before you actually are covered under that law. So which employers are covered by the law? Do you have a guess, maybe? Any others? State? Private companies?
I would say any contractor or grant receiving federal funds.
Could be. Any others? So the company must have more than 15 employees. If they have less than 15 employees, then we can't investigate. They have to have more than 15 employees. If they have less than 15, then they'll go through like human rights or the Department of Labor with regard to pay, depending on what it might be. So EEOC deals with companies that have more than 15 employees or entities with more than 15 employees. So the first thing we have to look at is, do they have more than 15 employees? And we need evidence to prove whether or not they do or do not. Someone mentioned state and local government. That's correct. Employment agencies, meaning recruiters, hiring agencies. If you're contact an employment agency whose job it is to help you find an agency, and they get or to find a job, they get your resume, and they set up the interview for you, they screen you, all of that kind of stuff. When you give them your resume and they said, oh, we're not going to interview you for that agency for a whole bunch of different reasons. Maybe you're deaf, your religion, whatever. That's discrimination. And you can file a complaint from the recruiting hiring agency. So the Rehab Act actually covers federal employees. So it's actually separate. So there's local, state, and governments, private sector, schools, Walmart, Target, any kind of business. If it's like a mom and pop, like a family business that has less than 15 employees, if they have more than 15 employees, then yes, but not if they have less than 15 employees. And someone asked about churches. So churches, it depends if, again, they have more than 15 employees, and if they are partially funded by the state, then they may. But again, and if you're an attendee, then no. If you actually work at that church, like as a staff member or something, or on the board or whatever, then it may actually apply. Any other questions? What laws does the EEOC enforce? So there's the Rehab Act. She asked if She asked if the Rehab Act was under the EEOC, and it's not. ADA, yes. She said the ADA. So Title VII of the Civil Rights Act of 1964. That's where I explained about the basis, where I talked about race, I talked about national origin, religion, all of that. That's actually under Title VII. And I also talked about the Age Discrimination Act, Age Discrimination Employment Act of 1967. That's where if you're 40 or above and discriminated against. So if you're 40 or above, it actually falls under that law there. What do you mean 40 or above? They're the people who tend to. What if you're younger than 40 and you experience discrimination? Why isn't it for the people below age 40? If a company, for example, let's see, if you work at a company, and let's say that person is 50, and you've worked there many years, and then they fire you for some reason, and then they hire a younger person, and maybe they were 30 or 25 or whatever, and it could show evidence of discrimination. Why did you hire that younger person to replace me? It would fall under that law there. Which she said that's still common today, form of discrimination, and I agree with her, it is. Equal Pay Act of 1963 means one person gets lower pay than another. Like if a female gets one amount of money for that same position, that a man receives more than that, right? Then that's not equal pay. They have the same experience, they have the same years in the job, then that would apply here. Genetic Information Non-Discrimination Act of 2008. It's based on your medical history. So any genetic information or history, pre-existing condition, family genes, if that affects if it causes discrimination in the workplace, then it would fall under that law. And I'm sure a lot of people here know about the ADA, Americans with Disabilities Act of 1990. And that's Title I is specifically about discrimination in the workplace and reasonable accommodations. Section 501 and 504 of the Rehab Act of 1973. There are specific workplace situations that fall under those. Okay, so I'm going to focus more about the Americans with Disabilities Act because that's what I'm here to talk about. You know, deaf people who experience discrimination are often filed under the ADA. So what is the ADA? In my opinion, ADA is weaker today than it was before because many people don't have jobs, which is worse than before because of various reasons. Attitude problems, maybe. They don't want to have to pay for interpreters. That's my opinion. Interpreters are expensive, and I think that affects the deaf community not being able to find jobs because companies don't want to pay. They don't know about the ADA. The ADA doesn't actually pay for interpreters. Let me go ahead and ask you some clarification here. Like today, it's harder for deaf people to find jobs. So the community is kind of upset about that, mostly because of interpreter issues, because they're expensive, because interpreters are expensive. And companies don't follow the ADA. Many companies don't want to pay for interpreters because the costs keep going up. I think it's not fair. That's my experience, and that's what I've seen. Okay? I don't mean to blame the interpreters. Like interpreters are selfish or whatever, you know. So I saw a Gallaudet teacher say the same thing, and I felt the same way. I feel it's the same way today. I'm sorry, I feel like they're selfish. Does anybody know anything else about the Americans with Disabilities Act? I'm a little bit surprised that the ADA law was actually passed in 1990. I thought it was even more than that. I thought it was like 1970s or something it was signed. Yeah, 1990. Yeah, under President Bush in 1990. I thought it was like a long time ago. Nope, it was Bush. But it was first introduced in the 1970s, right? Nope, 1990. Any other comments about the ADA? Okay, the Rehab Act, or the Americans with Disabilities Act in 1990 prohibits private employers and state and local governments, employment agencies, and labor unions from discriminating against employees with disabilities, against qualified individuals with disabilities. So the qualified part is important. So what is a disability? What is a disability? Deafness, person in a wheelchair, right?
So ADA also includes people with mental disabilities. For example, there's deafness, which is under it, people with a wheelchair, people with schizophrenia or bipolar depression. There's a whole list of people in that group. The ADA must have proof that it limits daily activities. It's also regarded as having an impairment. So if you, for example, take medication, even if you don't have medical proof, it still is, if the person regards as an impairment, it is still under EEOC.
Yes. What does it mean by major life activities? Is there a technical definition?
It means things that prevent you from doing your job. I'm deaf, I can do my job, but for example, so I can do my job, but I have a disability, but I must have reasonable accommodations. For example, I have an interpreter. Sometimes I request for CART for some meetings. I have a note taker. And I communicate with my other employees through Skype, and those are the accommodations that I use in order to do my daily activities, my work activities. For example, of all the different disabilities, they all have different reasons as to how the reasonable accommodations would manifest themselves in order to do your job. Does that make sense?
I was just specifically wondering, does the law have a very specific definition of what major life activities? I mean, are we talking like walking, hearing? How does it define major life activities? Or does it? Or does it not?
Do you have something to add? When someone voices a question, people might not be able to see the sign. So if one of the interpreters could come up onto the stage or sit there, or does that make sense? Yeah. Okay, I'm sorry, could you have your question again?
don't have to spend a lot of time on this. I'm just wondering, does the law specifically define what a major life activity is? Does it say walking, hearing, seeing? I know accommodations are needed to do those things, but how does it specifically define what a major life activity is?
Okay, that's a good question. For example, someone in a wheelchair. They can go to work, but they might have to have a bigger desk that they can move a ramp to get up to their desk in their workplace. Do you understand what I mean? No, it's okay.
Belabor it. I think I'm trying to get to more, again, I understand someone in a wheelchair needs a bigger desk, but again, that is the accommodation. It's not telling me the definition of what a life activity is. Like, I think of life activities as being walking, hearing, seeing, being mentally healthy, I guess. So I'm just wondering, how is that defined? Because to me, it seems you have to have the definition of that to know what then would be covered. We don't have to spend a lot of time on that.
Okay, I understand what you mean. For example, under the ADA, it does cover what you can't do. Like, you can't hear, or you can't walk, or you have schizophrenia. There are many, many more that are under that. Does that answer your question? This also can include eating and swallowing, and having to go to the bathroom very often. Physical things that you might not be able to see or might be obvious, such as someone who's in a wheelchair is a lot more obvious. But this also includes things like anxiety or OCD or bipolar or PTSD, yes. So I think that, yeah, that is what I remember. Yeah, not visible. It doesn't have to be a visible disability. That is under the major life activities. What do you think? Yes. Yes, they are. Deaf people are covered by the ADA. But also other people with disabilities are covered under the ADA. It's not only deafness, it's disabilities in a broad sense. Who is qualified? Who is a qualified individual? So what that means is that they have necessary skills, education, experience, and job-related requirements. So the ADA, under the ADA, they have the ability to do the job. They can do the job with reasonable accommodations, with or without reasonable accommodations. So once they have the reasonable accommodations, then they can do the job the same as their hearing peers, or non-disabled peers, or non. Different common types of discrimination is failure to provide your accommodation, disparate treatment, such as not giving them the opportunities that they would give the other hearing peers, for example. a hostile work environment. For example, would be how a boss would treat you if they would not punish you or treat you differently than you would their other peers. And also retaliation, which I will explain more later. So, what is reasonable accommodations? Would be a modification, such as if you're in a wheelchair, making sure that you have a ramp, making sure that you have enough space and you're able to go around your office. A deaf person might have lights, and make sure that they have visibility so that they can see someone who is coming up to their desk, and that they're able to do their major functions of their jobs, such as they have a note taker, they have an interpreter. Blind people use a special kind of software so that they can see their work. And also so that people with disabilities have the same rights as and same access to their job as any other person without disabilities. Who's entitled to a reasonable accommodation? Deaf people? Anyone else? Anyone with a medical disability, medical documentation of a disability. Employees who have a disability, everyone who has a disability that is medically documented needs to be accommodated. So give me some examples of accommodations for deaf people. Interpreter, video phone. Anything else? Note taker. Cart for meetings, such as the one we have here. Captions for people who are hard of hearing on the phone. That's correct. We have a sign language interpreter. Cart, like she mentioned. Note takers. Video phone. Instant message and Skype. This happens a lot throughout the communication with other people in the office. That's my favorite way of communication with my colleagues. Flashing lights, emergency lights, for doorbells for the office, and different kinds of emergency alerts. Do you all know what a deaf workspace means? Like round tables, for example, or so that everyone can see each other around the table. A deaf space means it's a lot more visual, and so deaf people have access. My office, I have a L-shaped table so that I can move my table, my workspace, so that I can see people coming. If I'm sitting in the corner and someone comes up behind me, I can't see them and it scares me. So I moved it, and then I can see people coming, and it works a lot better. It's important to make things visual in your office, in your workspace. If you have a cubicle, you can ask to move to a different cubicle that might have a visual alarm, so that you can see the alarms better if you're in a cubicle that's far away from where the visual alarm is. This word deaf, deaf can mean anything from mild to severe deafness. Deaf people don't always use CART. They don't always use interpreters. Sometimes they're oral. Sometimes they don't use that. Yeah, accommodations can mean a variety of different things. It depends on the individual. Some people don't want an interpreter. Some people want a certified deaf interpreter. Some people want ASL. Some people don't want ASL. So it depends on the person themselves, the deaf person themselves. Any questions about this? Okay, so what is the employer's responsibility? They must engage in an interactive process, which means if you tell someone that they need an interpreter, now it's their responsibility to start that process. They don't just ignore your request and say, I haven't seen them in a while. No, you have to if you let them know that you need something, then it's their responsibility to respond and to start the process of satisfying what you requested, what you need. If you request an interpreter for that day, you start the process of getting that interpreter. But you have to inform them, yes, I'm deaf, I need these accommodations. And then they are responsible for starting the process and not just sitting back and letting nothing happen. Like someone mentioned, ADA has many different parts, and the interactive process is different for each individual. It's not the same, one size fits all. Remember, undue hardship means some companies might be a small business and they can't afford to get an interpreter. They can't afford to satisfy the reasonable accommodations of an employee. And they might explain that they don't have the budget to provide an interpreter, and they can prove that providing an accommodation would cause undue hardship. Big companies might say that, but I'll say, okay, give me your budget and we'll see. And many companies will try to claim undue hardship, but they're just trying to skirt the law. Any questions about that? So my question is about undue hardship. What percentage of a budget, do you have a formula or something that businesses can say that I can't afford this, and that you come and you look at the budget, and how do you decide the percentage, or how do you decide what is considered undue hardship or not? If a company says that they cannot provide because of undue hardship, we look at how many people work there, and we ask for their budget. And when we look at it, if they see that they have enough money to provide interpreters, then we deny that claim. So we have to make a determination. If we look at their finances, it really depends on the situation. Every company is different. We don't have a specific percentage. It depends on what you do with it, on how much you pay for reasonable accommodations, which also depends on the situation.
So my next slide talks more about undue hardship. So they'll say accommodation is too expensive, too difficult to acquire. The employer must prove undue hardship based on their financial resources and the size of their business. Like a mom and pop shop, or maybe a business that's just setting up, just starting, they may not have enough capital to be able to provide a reasonable accommodation, but if for a big company, there's no excuse. Employers must show their expenses, and that would be burden on the entire business. Does that answer your question, Eileen? Okay. So what is the employee's responsibility? The employee must disclose that they have that they have the disability and request a reasonable accommodation. The employee must be responsible in the interactive process. If a person says, hey, I have a reasonable accommodation that I can provide for you, and then the employee doesn't respond, you want that interactive process to actually take place. The employee must be engaged in that, in finding the solution for what the reasonable accommodation is that they need. They can ask for specific things and then say, like, let's talk about what might be effective. You have to sort of try maybe different ways, maybe. It's sort of a compromise to make sure that you can get the reasonable accommodation that you need. So what is effective communication? Make sure that employees are able to have access to the communication and that the communication is effective, it's transparent, that there's no gaps in it, that it's comprehensive. I had a brain freeze. So how do you request a reasonable accommodation? You have to identify what you need. You can't just say, I need a reasonable accommodation. What kind of reasonable accommodation do you need? Sit down and talk to your supervisor. Have that interactive back and forth about what would work. Also, look at your company policies. Read and ask questions that you're following, making sure that you're following the right procedures. Talk to HR if necessary. I don't tend to talk directly to HR. I tend to talk directly to my supervisor, tell my supervisor what I need, and my supervisor talks to HR. It's my supervisor's responsibility to coordinate that with HR. So I let my supervisor take care of that. They know who to contact, all of that. So right here, no magic words. So I just learned from one of my seniors is that when you are requesting an accommodation, there's not like a form you have to fill out. You just need to say, I need an interpreter. You don't have to explain why. It's very simple. I need an interpreter. That's the sentence you need to say. That's it. And you get the reasonable accommodation. People think, oh, there's a certain form I got to fill out. There's certain language I got to use. There's certain words I need to say. There isn't any of that. It's good if you were to type it up because then you have sort of the evidence that you said so, that you said that that's what you needed. We had one complainant who wasn't a very clear signer, but I realized that they needed more than something. So I said to the supervisor, they need a CDI for the meeting. And I said, and the supervisor said, great, and got them a CDI, certified deaf interpreter. And it was pretty simple, right? Just put in your mind that there's no magic words. All you have to do is ask. I'm sorry, did you have something? Yeah, nothing. She stepped out.
What is a certified deaf interpreter versus just an interpreter?
Okay, a certified deaf interpreter. So you see we have these two hearing interpreters. They're interpreting for me. If a person who is deaf, who signs, and they sort of might do copy sign, for example, they might do that, but all deaf individuals don't understand ASL, right? Maybe language deprivation issues, maybe mental issues, whatever it might be, then they'll have a deaf person who will sign it a little bit differently, trying to identify and be able to communicate at the language that that particular deaf person requires. It depends on their communication, their history, where they're from, their education, so often a CDI is able to help. Like you'll use them in meetings, in court, and they're sort of ASL experts and are able to alter their language to meet the needs of that person. Is that clear? Somebody else wants to add something? Some deaf folks are at low levels and the interpreters actually can't understand them. So you bring in a CDI to sort of help facilitate that communication, maybe gesturing, just to kind of meet the needs of what that deaf person needs. So it's really based on language deprivation and not having language from a young age. Okay? Okay, so now we're going to talk about disparate treatment. It means individuals of a protected group being singled out or treated less favorably than others. So if you have like a holiday party, for example, and everybody's socializing and the deaf person's all alone over in the corner, they don't need an interpreter, it's a social event. And everybody's socializing, that's discrimination because you're not allowing that deaf person to be a part of that festivity. You know, you want to make sure that they have an accommodation for that particular social event. Or somebody gets a bonus or somebody gets an award and we say, oh, the deaf person doesn't need that. Or maybe give the hearing person more work and the hearing person less work, let them chill out and give the deaf person more work. Clear? So these are some examples. Like a company function, a deaf person being involved in a company function. Most of the time they'll say, oh, we don't need to include that deaf person. Like giving the hearing person less work and giving the deaf person more work. That kind of thing. Some people will, like during breaks, somebody will have a long break and they'll tell the deaf, like hearing people will have a longer break, or they'll tell the deaf person, hey, it's been 10 minutes, time for you to get back to work. Here's another example, a deaf person who's not able to get promoted. You see hearing people that are getting promoted and the deaf person says, sorry, you're going to stay in that same job for a whole bunch of years, you're never going to be promoted. Another might be if a deaf person continues to get disciplined where for the same actions or whatever, the hearing person is sort of getting, oh, that's okay, you don't have to, we're not going to discipline you for that action. Hostile work environment and harassment. Depends on behavior by the company. Maybe giving someone a hard time, bullying them, ignoring them. Or maybe putting someone in the corner. Like a better table for hearing people and a dark table in a corner for a deaf person. So the hostile work environment or the harassment needs to be severe and pervasive. It's a one time, then that's not really a complaint. But if it's something that constantly is happening, then you have documentation, you can actually prove discrimination. If they mock you because you're deaf, sort of laugh at you, that deaf guy, right? Mock, mock the signing, things like that, laughing and sneering. Okay, retaliation. It's an adverse action after a complaint has been filed. So if somebody files a complaint to EEOC and says, this is what's happened, I've been discriminated based on the fact that I'm deaf, and then the company finds out that you're the one that filed the complaint, then they try to retaliate against you. They'll write you up for some silly reason, they'll give you more work, or if you complain to HR about a boss, then the boss retaliates against you. Like same kind of deal, like writes you up, puts you on a performance improvement plan. So like a adverse employment action after a complaint is filed. Could actually lead to termination if you file a complaint. Maybe demotion. Maybe they reduce your pay. Maybe they change your schedule. Maybe they deny your reasonable accommodation. All of those are signs of retaliation. About disparate equal pay. So would I fill out a complaint with them if they didn't like, so disparate treatment, if they didn't invite me to like a holiday party, would I be able to file with the EEOC? If they didn't invite you, like, every single time you kept asking for interpreters, then you're not being included. So you're being sort of excluded in that instance. So like holiday parties, You know, you want to make sure they have I, as a deaf coworker, I want to go to that holiday party. Hey, boss, I'd like to please make sure I have an interpreter. You know, you're missing out on some of that business discussion. But I thought parties were sort of considered social events. It's not really work event. Actually, if it's a holiday party during work hours, then yeah, it's a work event. And equal access, those hearing people are able to attend. I mean, I have a fabulous team that I work with, so they're very inclusive for me for holiday parties and any events that I go to. But if they say, oh, no, we're not going to provide a reasonable accommodation, then that would be bad. What if it's an after-work party? Then that wouldn't be considered work hours, right? I mean, after-hours holiday party, there tends to be everybody's sort of communicating together. So where I work, there's two deaf people plus staff interpreters, and it's amazing. There's a lot of, everybody's inclusive. There's engagement through text, there's engagement through chatting. For my husband, I don't know if he would experience that. I mean, I'm not sure. Wow, interesting. But after hours, it's up to you. But I tend to go for after hours. I'm lucky because the interpreter will stay. They'll make an effort to, my staff, the people I work with, my coworkers, will make an effort to communicate with me, right? So I'm even, you know, but the law is based on during work hours. Even though a holiday party is a social event, it's still during work hours, right? If you finish work at like 2 and the holiday part's at 3, because that's the schedule, you know, you can still get an interpreter for those hours, for those work hours. She says you're lucky you work at a federal government where there's more deaf people who work there. So let me say, some people who are federal employees also experience discrimination. Don't think, oh, federal government, better opportunity than non-federal. That's not true. It's that people who work in federal agencies also experience discrimination. I'm just lucky because I have a fantastic team. They're amazing. I think it depends on each organization, but still you have to follow the Americans with Disabilities law and make sure that you have access. You know, we have real world people in the world have, real world people have a harder time, I think, getting access. Again, treating people differently in the workplace like that is a discrimination, is a violation of the law. So if you know that you have rights to file with EEO or EEOC, you know that you can file because of that, right? So knowing what your rights are, getting exposure to that, whether you're for a federal employee or a non-federal employee, just knowing that you have those rights, that's what's important. So how do you file? So 300 days to file. For, let's say, last year, January, I had the discrimination in January. So then I have 300 days to file with the EEOC. If it goes past that 300 days, then I can't help you with that. Our authority is in that 300 days. If you were fired, then or you're currently working. Say that one again for me. So if you're still employed and you file with EEO, you have the 300 days to. So if okay, I got it. So if discrimination happens and you kind of file within the agency, like with EEO or whatever, and then later you get terminated, your actually 300 days doesn't begin until termination. Right, and that's when your 300 days count begins. Monica's going to explain more about how to file, how to fill out on the EEOC online portal. We used to actually have a hard copy form, but now you can do it online. It's so much easier, so much smoother. So what you do is you fill out online, you make an appointment, what kind of reasonable accommodation you had, and then we can do the interview either in person or on the phone. If people who want to come in, then it's a little bit more difficult, but it depends on how many people want to come in and do it face to face. So we look to see what kind of evidence you have. We'll ask you a bunch of questions, and we'll type up the summary charge. And you'll sign it, and then we'll do mediation. Does everybody know what mediation is? Yeah, it's communication. It's like so the company, the respondent and the claimant will come in, and we'll see if we can settle it there with us. If that succeeds, then we don't have to proceed with the investigation. If there's no negotiation, if nobody agrees, then we proceed with the investigation. So we'll take the company's position or the company's statement, and we'll send it to the person who filed the complaint, and we'll get their appeal, or their response. We have 120 days to do that, and then we determine if there's a violation or not. It can take 6 months to a year or more. It depends on how severe and pervasive it is. If we proceed through and we see that there's no discrimination, we'll send you a right to sue letter. That means you have 90 days to file. You have 90 days to file in court. And that'll be without our participation. That'll be like you'll get your own lawyer, your own advocate, whatever. If you feel that there was discrimination, there is possible to do a lawsuit based on the type of case. About 90% don't actually tend to go to lawsuit, but you do have a right to sue. Yeah, that was the part I just explained about people what does litigation mean? That's possibly the right to litigation, meaning to sue. So this is the form where we're going to put the summary of what happened. We're not going to disclose your disability. We send this to the company. So this is the only form that they actually see. And the summary is a little bit vague. We want it to be vague enough so that they can't necessarily figure out who it is that's filing. If we need to. And this is all they get, this one form. And this is some resources that you can file, the EEOC website. I had some cards over there with our VP phone number. And you can ask us questions, and we can refer you to the right office of which office that will help you with your filing. We also have internship opportunities as well. EEOC has 7 deaf investigators across the U.S., 2 in New York, 2 in D.C., 1 in Florida, and 1 in California. Any questions?